Welcome back to Cover Your Assets. And yes, we are here to help you stay alive in this new now, as Craig Nestor likes to say. Todd Rooker is here also, Jason Walgrave, and we're talking with David Kingsbury. This is Bankruptcy, an arrow in your quiver. And you can join us too if you do have a specific question, 855-835-8500. So Todd, right before we went to break, you were just getting into some really meaty information that I think a lot of people would love to know about bankruptcy.
Well, the way that a person qualifies for bankruptcy is not what they think. They tend to think that they can if they want to file bankruptcy, they can, and anybody can just do it. Well, that's not true at all. And as David described in his practice, there's, for the most part, two types of consumer bankruptcies, Chapter 7 and Chapter 13. What determines which direction you go may have little or nothing to do with the debt per se. You may have a lot of debt, and that's why you're here, but your qualifications to do it really have more to do with that than the amount of debt. In other words, if a person makes $40,000 a year, if they've got $50,000 in credit card debt or $100,000 in credit card debt, that's not the formula that's going to be used to determine if they qualify for bankruptcy. It's going to be a number of other things, four of which David was leading into. So, David, go right ahead with those four items.
I will. And the debt, it's almost an afterthought. The four key analysis that we make is means testing, which is part of the new legislation. You're above or below median income is kind of a simple way to look at it. It gets more complicated than that, but that's one of them. Disposable income is the other. We take a look at what your actual net income is today, not historically, but what you're making now. And
which is your capacity to be in a payment plan, basically, if you've got the disposable income to do it.
We're looking at net income, subtract from that necessary, reasonable living expenses that the court allows. And you can't look up anything that tells you what that is.
Therein lies the finesse.
Therein lies the art to it, yeah. And then we take a look at what kind of assets you have, what kind of equity you have in those assets, and whether or not we can exempt them under the applicable statutory scheme, either under the Federal Bankruptcy Act or the Minnesota state statutes. Most people don't realize you can keep houses and cars in bankruptcy, and I get a lot of people calling me, I want to keep my house, I want to keep my car, and if you can pay for it, that's not a problem typically.
And it's interesting because people tend to believe the last resort is bankruptcy, because when they come to see me, they'll tell me the one thing that they want to keep above all else. In other words, if they circled one thing and only one thing that they could keep, it'd be their house, and they look at bankruptcy as being the last and worst case scenario because they believe they're going to lose their home, when in fact bankruptcy can be one of the best mechanisms to allow them to keep their home in so much as they can exempt it, and now they don't have the debt and they have a greater capacity to be able to make those payments consistently, ongoingly.
Exactly, because if you flush the unsecured debt and you're not making payments on those any longer, you're in a lot better position to make your house payment. And if for those of us of a certain age, you can remember old cartoons, you're wearing a barrel with a couple of straps. That doesn't happen. The whole idea, you'll see it in the language for bankruptcy, fresh start all over the place. It's enough to give you a fresh start. They leave you with enough to get a fresh start in life, and that's the whole idea. So you can sleep at night, you can still survive, you can provide for your family, you got a place to live, you got basic transportation, household goods, those kinds of things you get to keep. And I did want to touch on the final analysis that we make in a bankruptcy consult situation, and this is one where people get tripped up quite often. Craig and I had talked about misconceptions at one point. Transfers of assets, and that's the biggest mistake people make before they come in to see me. They've sold a car to their brother for $1. They transferred their interest in their family cabin to their siblings. Things like that. A lot of folks, if I have clients from South Dakota, the first question I ask them is, are you on the family farm? So if you've got assets that you're interested in, don't transfer them. For us, in terms of doing a bankruptcy analysis and actually getting somebody filed, if I could put my thumb on somebody and make them stand still so they weren't doing all kinds of things that I wouldn't want them to do, that would be a lot better. It's not a perfect world. That doesn't happen. But before anybody does anything as far as changing what they've got going on, they want to go and seek competent legal counsel about bankruptcy first.
Because the courts will figure that out. They'll see, right, Todd and David, they will go and say, this looks suspicious, and can't that come back and have negative impact?
You would not believe the amount of detail that's required. A typical bankruptcy petition is 50 to 60 pages long. The disclosures are phenomenal. You have to provide 6 months worth of income statements or pay stubs or other income. You've got titles to cars, property tax statements. There's a part of the petition that's called the Statement of Financial Affairs where you disclose all of your transfers. They will ask about transfers to family members going back 6 years, so a person's got to be careful about how they handle their transfers and their assets. Yeah.
And that's part of the problem with the complexity of something like bankruptcy is that people will talk to their brother, sister's cousin, or talk to somebody in a bar somewhere, and they get a straightforward answer to a simple question, and they believe that that's simple and that's all they need to know. In other words, well, they only go back 2 years, so you don't have to worry about it. Well, maybe they only ask that on the petition, but the reality is, if you make transfers for if a creditor can prove, because creditors have an opportunity to bring their case as well, and if they say, look, you were making transfers 3 years ago because we had pressure on you, and you were specifically trying to take assets that were non-exempt and put them into an exempt status to avoid paying us. That type of conversation is something that can take place in bankruptcy, and that's why this hard line of 2 years, 6 months, what have you. There's a lot more complexity surrounding this stuff.
Well, there's preferential payments, there's transfers, and it's not really so much creditors. It's the long arm of the bankruptcy trustee, whose job it is to collect assets for creditors.
Who is not your friend.
Who is not your friend.
Ask
I tell
Denny
it to
Hecker.
my clients. Ask Denny Hecker. He's looking for a cellmate. And before I go into hearings, I say the trustee is a nice person. They may sit there and smile. They are not your friend. Their job is to take money from you or to take money or assets from people you transferred assets to. So you have to be careful about it. And I thought it was funny about what you had commented just a moment ago. One of the best pieces of legal advice I give to people is absolutely free. It's do not take legal advice off of street corners. You may have an uncle or an aunt or your cousin Bob that did a bankruptcy. His case is not like your case. They're like snowflakes. They look alike from a distance, but once you really look at them, they're all different.
So how do people reach out and get in touch with you, David Kingsbury, Kingsbury Law Office?
My website is a good place,
okay.
www.kingsburylawoffice.com. We have offices in Rochester and Apple Valley. The phone number, if anybody's interested, is 952-432-4388.
And you can also find that by going to our website, coveryourassets21.com, and be able to find David. The misconceptions related to bankruptcy run rampant. And as I've said, one of the best opportunities to save your house may actually be a bankruptcy because it puts you in a strong position. So it is not the last thing in the world. It may be actually, if your primary objective is to keep your home, bankruptcy may actually be a tremendous tool to be able to do that and could actually set you into a position where you're better off than you have been in more than a decade because now you actually can afford the house payment that you've got. You've cut loose of the debt, and you're able to move on and rebuild your life. One of the things that people, I think, do not think about is that bankruptcy as a strategic tool to maintain your financial picture or position is absolutely a viable proposition. Too often I find people who come in are exhausting their retirement account simply to make their payments on time. That retirement account is an exempt asset all the way to bankruptcy. So if you go to the wall, you can preserve up to $1 million and actually even more before it's been challenged, $1 million in a qualified account and still be able to discharge your debt and move on with your life. However, if you take those dollars out of their protective status within a qualified retirement account and use them to subsidize making the payments, you are simply often delaying the inevitable, and then the very money you've taken out will be counted as income and maybe the reason that you don't qualify for bankruptcy. Now you've eroded your financial position. You wind up losing the house anyway, and now you don't have the retirement account anymore either. It's a huge mistake that people make.
And I think all of you could say this. Jason Walgrave, Todd Rooker, definitely Mr. Kingsbury, our in-house attorney today, and Craig Nestor. He said don't take legal advice from bars or off the street. These terms like bankruptcy, short sale, all of these different things, because they're becoming more common, people on the street think that they know what they are.
Well, going through bankruptcy doesn't make you an expert. Going through foreclosure doesn't make you an expert. And David, in many cases, we're trying to keep homeowners in houses, and we are trying to fend off sheriff sales to make that possible, to buy them time, to re-engage employment. Tell me how bankruptcy applies to a sheriff sale and how we're able to use that to, well, if we're going to file anyway, let's at least push the sheriff sale out. How does how does bankruptcy protect us from a sheriff sale?
Well, bankruptcy stops a sheriff sale dead in its tracks, actually. There's a provision of the Bankruptcy Code known as the automatic stay, and I won't bore you with the actual statutory section number, but it's an automatic stay against creditors from engaging in any collection activity whatsoever. Mortgage companies, credit card companies, collection attorneys, the IRS, anybody. Once the case is filed, and it's called automatic because you don't have to do anything but file the case, it crops up automatically, and it will stop a sheriff's sale, temporarily at least, to give you some time if you don't come up with a plan, either by filing a Chapter 13 to catch up the defaults, or if you're just in a Chapter 7 where there is no plan to do that. If you're still behind, they will eventually file a motion to the court to ask the court for permission to ramp the foreclosure back up, but it will buy some time. And even if you're in a redemption period after foreclosure, it will extend your redemption period by a couple of months.
So if the sheriff's sale has occurred and I'm in the 6-month redemption period, by filing bankruptcy, it affords more time?
You have to do it prior to sheriff's sale to get the foreclosure to stop. After the foreclosure,
once the sheriff's sale has happened, the foreclosure, I'm not a real estate attorney, but the foreclosure process is pre-foreclosure. You get all kinds of nasty letters from the attorneys that were assigned the file from the mortgage company, but you get a notice of foreclosure. The sheriff's sale is set out for 60 days after the notice, and you're in what's called the reinstatement period at that time, where you can just get caught back up. But if the sheriff's sale occurs, you are then in redemption. And for residential property that's occupied, that's 180 days. Redeeming means you pay off the whole note. You just can't get caught back up again. But I can still file, and we just did that for one of Craig's clients last month. They were coming up to the end of redemption period. They needed some more time to work out something with their attorney on some issues regarding their mortgage. We filed them the last day of the redemption period and bought them another 60 days.
Very good. David Kingsbury, Kingsbury Law Office. You can find him along with all of our other partners here at Cover Your Assets at coveryourassets21.com. That's coveryourassets21.com. We'll be back with more with Jason Walgrave, Todd Rooker, and Craig Nestor.
When the weather is high, you can stretch right up and down.